Good afternoon, everyone. Thank you for joining us this afternoon. My name is Sarah Pinder, and I'll be co-presenting this webinar with Samina Iqbal. We both head up the immigration team here at Goldsmiths, and today we'll be presenting a webinar for you called EU Settlement Scheme, essentially as much as an update as possible. Just a few things to flag up at the start, if I may. The webinar, we've asked, if at all possible, for persons who are attending to make a donation. Of course, that's voluntary, but we've suggested a £5 donation, and we've nominated two organisations that you may wish to choose. Those are first SARI, which stands for Stand Up Against Racism and Inequality. So obviously very topical with Black Lives Matters and all of the events that have been happening most recently. But it is an organisation that also is much more of a bigger umbrella in terms of racism and inequalities more generally. And then the second charity organisation, or certainly organisation that we chose, is the 3 Million, which you may have heard of. It was set up after the referendum for Brexit in order to campaign, to lobby and to try and protect the rights of EU and EA nationals as much as possible. But of course it's all voluntary, but we're just flagging that up. You have the links in the invitation email and also in the slides. When you come to look at the slides that we're going to be using, you will see some hyperlinks in the slides. So it's all live when you will be able to download those. So all of the guidance, all of the provisions, the statutory provisions, the regulations and so forth are hyperlinked there for you to access as easily as possible. And we will be making the recording of the webinar available to watch and the slides available to download from Monday of next week. You will receive an automated email telling you where to access those, but also they will be uploaded on our website at the earliest from Monday. So no need to check tomorrow or before Monday. And two last matters. So the penultimate is the Q&A. So we will have time for questions and answers, hopefully at the end. Please type your questions in the Q&A box, which you can find at the bottom of the Zoom platform. Please don't put those in the chat, as it will be difficult for us to monitor both, but in the Q&A box, and we'll do our best to reach as many questions as possible. And at the end of the webinar, we'll also launch a poll. So a screen will pop up onto your, a box will pop up onto your screen, just setting out a question that we would like you to answer. So please take the time to do that before you leave the end of the session. But without any further delay, again, thank you for joining us. EU settlement scheme and for an update. So we're now into the scheme for a good number of months. And we will try and cover as much of this as possible within the time constraints of obviously a short session of 30 minutes or so. You have here on this slide an overview of the topics that we'll cover. Initially, it will just be a reminder in terms of the dates, the relevant dates from the withdrawal agreement, transition periods, and so on. The second area will be the Appendix EU and the settlement scheme itself. Just to flag here, it's separate to the Appendix EU family permit, which is looking at entry clearance applications. We're not going to cover that. It largely mirrors the in-country scheme as well, but we are, for this purposes, concentrating on Appendix EU alone. And we will provide some updates pre-COVID and those that were announced during the pandemic period as well. Who is covered by Appendix EU, so what types of EEA nationals? There's been some developments on that front that we'll cover. Any difficulties that are experienced during the pandemic that have now also been reflected in guidance, we'll cover those as much as possible. And really lastly, two areas, both the remedies in terms of administrative reviews and appeals, how that has developed and the timescales involved there. And lastly, a few cases that might be relevant still, both for more wider EU issues, but also for Appendix EU. The Brexit effect at the end is essentially our Q&A session, and really to summarise perhaps a general state of confusion, of frazzleness that might summarise really our experiences of this area. So we'll just continue on in terms of the dates. So you have here in this slide really all the relevant dates. A word of caution, it is really all subject to further change as we perhaps see the negotiations continue later on this year. But as you will no doubt know, the withdrawal date is now official, has happened, and that's the 31st of January 2020. It is a relevant date that takes us into, for example, appeals, we'll see later, but that is certainly the date for now, 31st of January 2020. The deal in terms of between the UK and the EU, 24th of January 2020 signed, with the transition, also known as the implementation period, lasting until the 31st of December 2020. So that is the date that may shift. We'll have to see. For the moment, it's a relevant date because it does provide a stopgap for several categories in the Appendix EU scheme. And as you will see also, the applications under the EU settlement scheme are open until the 30th of June 2021. So they do go beyond what is foreseen as the transition period for now until the 30th of June 2021. There have been calls to extend that application period within the EU settlement scheme, but that has been ruled out so far by the Secretary of State. So you have that in the fourth bullet point. So it was announced on the 29th of April. Mainly, as far as we understand, the calls to extend the period by which in which we can make applications was due to the fall in numbers that were being received, fall in numbers of applications that were being received under the scheme, as again a direct result of the pandemic. But as mentioned, that's been ruled out for now. The 3 million campaign, which I mentioned at the start in the context of the donations, the suggested donations, is still campaigning for that to be extended because there's really a problem with the statistics, a problem with knowing exactly who has applied, how many left have got to apply. And there has been more widely some criticism of the numbers released by the government. So some months ago, success was being called for high numbers having been made, high numbers of applications, when in fact that did include repeated applications from the same person. So perhaps an application had failed for some reason, due to documentary reasons, for example, and that person had reapplied. Those two applications were being counted as separate applications, as in separate individuals. So we've certainly got to be cautious when looking at the statistics and taking any conclusions forward from those. But for the moment, 31st of December 2020, the end of the transition period, and for the moment, 30th of June 2021 is, on the whole, we'll see later why, the end of the applications under the scheme until we hear otherwise. The last more general update you have in the last bullet point on this slide is just a brief reference to the European Temporary Leave to Remain scheme. That was a scheme that was announced earlier last year, I think, or very early this year, I forget exactly, to basically cover post-Brexit, the regime, the framework for EA nationals to apply to come to the UK. Very much a scheme mirroring other immigration categories for third country nationals. Now that scheme has been scrapped as we knew it, although I don't think it ever really came into much existence. But if you hear any references to Euro temporary leave to remain, that's gone and not really something that you need to look into. And then obviously there needs to be a new system devised and put into place, but that's still very much being debated and being looked at currently.
Thank you. And that takes me to the next slide, which is talking about the actual settlement scheme. Now, it's going to be very difficult for us to cover everything within the settlement scheme. So what I intend to do is just look at eligibility with reference to the resident element of it. I think everyone knows now that you have to have been residing in the United Kingdom by the 31st of December 2020. There is a caveat to that, and that is if you have historic continuous residence of 5 years and you're outside of the country. So you can still apply under the settlement scheme if you're outside of the country with this 5-year period. As long as, I think, it's not lost. So as long as you haven't been out and you've lost your permanent residence, but that is worth looking into for certain clients if they're outside of the United Kingdom beyond that date. Insofar as family members are concerned, they simply need to demonstrate that the relationship was established by the 31st of December 2020. There is a nice little exception there, and that's with reference to children born or adopted after that date. They will still be covered, so that's quite reassuring, essentially, and it's essentially demonstrating what we've been hearing throughout insofar as the settlement scheme is concerned, about the flexibility of the scheme and ensuring it's as wide as possible to catch all, essentially. Now, this is a more interesting category, dependent relatives. It's a new category, and it's a category that we've seen and encompasses what we've seen before in the regulations, extended family members. Those they have to also demonstrate that they've been resident here by the 31st of December 2020. But what's interesting in relation to dependent relatives is that it's got a very extensive definition, more so than what we know or what we saw with extended family members. And I think what's going to be important, and we've hyperlinked it here, is to look at the definitions within Annex 1 of Appendix EU. It covers it covers children of durable partners who are not children of the sponsor. So that again shows the widening of this particular category and the trying to catch all essentially as much as possible. But we see there as being a potential difficulty with reference to this particular category, because there is reference within Annex 1 that they must hold a relevant document. Now, that relevant document, according to what we know with reference to case law, which Sarah is canvassing a bit later, is a residence permit, a family permit, or a permanent residence card. So those kind of documents, it's going to be difficult to see where they've introduced a new category of individuals under dependent relatives, how they would have held such a document prior to making such an application under the settlement scheme. So I think insofar, I can't take it any further insofar as that particular conundrum is concerned at the moment, because it's a very wide area and it's very difficult, I would say, a complex area. And certainly if there's an interest in discussing this a little bit more widely, we're open to further webinars on it, and please do share with us if you're interested in that in the chat function or by way of question and answer during the course of this webinar. And of course, you can email us too. What we also, and just moving from there, and I will come back to that when I'm talking about another category of individuals, but just moving on from there, if you arrived in the UK after Brexit, but during the transition period, you can still apply to the settlement scheme as long as you make that application by the 30th of June 2021. There is an exception to certain categories, and that's one of the special categories that we're going to be dealing with today. And that first category is British citizens. Now, British citizens are what we know to be Surinder Singh cases. They fall within Regulation 9, and they would need to demonstrate that they meet the definition of a qualifying British citizen, again, under Annex 1. So again, it's something that you're going to have to look at with reference to your British citizen national and whether they can tick all those boxes. We suspect it's quite a nice wide definition, so certainly I hope that covers a lot of individuals who have exercised treaty rights outside of the United Kingdom. Now, insofar as their family members are concerned, particularly for the spouse, durable partners, children, and dependent parents, there's two different dates, essentially, that I'm going to highlight to you. And that's if you've had a relationship before the withdrawal date, then you must return before the 29th of March 2022. So that is a longer period of time given to specific British nationals, family members of specific British family. So let me say that again. The family members of specific British nationals are given a wider or a longer period of time in which to make their applications. Now, we suspect that the reason for this is that the definition of extended family members of qualifying British citizens has only recently been included within the scope of Regulation 9, and that's as of the 29th of March 2019. Certainly, there was extensive litigation on this issue by colleagues of ours in Chambers, Tony Metzer and Sana Sefulahi, and everyone will know the case of Banja. So we think that it reflects essentially the change to the regulations to be more inclusive insofar as the definition for durable partners was concerned. If the relationship was formed after the withdrawal date, so between the 31st of January 2020 and the 31st of December 2020, they must return before the 31st of December 2020. I think that's quite straightforward. Now, again, there is another category of individuals in British citizens that need to be considered, and that's the dependent relatives. This is slightly more, the nuance here is slightly different, because what you're looking at here is the relationship is measured by reference to the existence of that relationship rather than the withdrawal date. So all they need to demonstrate is that it existed prior to the return to the United Kingdom. And that's different from what we've seen to the above two categories. And again, I think this is the widening or the flexibility shown within the settlement scheme, and it becomes more important for us to look at all the guidance a little bit more carefully. And we flagged up certain pages of the guidance which we think will help with reference to British citizens, particularly these particular issues that we raised here. But certainly, as we've said, this again flags up the fact that the issue or the difficulties for dependent relatives and the definitions of that are much wider. It's a much more complex issue, and that we need to look at it a bit more carefully when we're looking at generally dealing with making applications for such individuals. I'm going to hand back over to Sarah in relation to the other two elements or special categories that we wanted to flag up for you.
Thank you, Samina. So the next category, still within the framework or the definition of the EEA nationals and qualifying nationals for the Appendix EU applications, is the next major category is dual nationals. So and certainly Samina's experience as well is the same, is Annex 1 and the definitions contained in that is really your go-to place to check when you're advising or making an application. But it is very difficult to read. There are a lot of subcategories, a lot of Roman numerals, and so it is quite hard to follow. So go-to place, because obviously that is the primary source that you need to work with, but the guidance we have found slightly more accessible, and you have that hyperlink there again. A very quick mention on the guidance, the gov.uk page is very useful. You have the first set of guidance is a sort of overarching piece of guidance, I think 150 odd pages long, but then it is divided into subsections for some of the more specialist categories. So for example, the dual nationals or the EEA national, the British nationals that Samina's just covered, that has its own separate guidance, which is useful as well. Essentially, dual nationals, it is limited to the category of dual nationals that were essentially corrected by the CJEU judgment of Lunes, which you have just as a brief mention at the bottom of the bullet note there. So it was through that litigation that this category of persons was corrected within the regulations, and obviously has now been put through from the start, I think, in Appendix EU. So it concerns EEA nationals that have come to the UK, so they've exercised their free movement rights and treaty rights to come to the UK and obviously subsequently become a qualified person as a worker, for example, but who have later, having acquired their permanent residence, later naturalized as British. For various reasons, such a person may not make an application under EEA law until they've naturalized as a British person. So they might later marry, and that person, for example, might be a third country national. And it's only when they have become a dual citizen that they might find themselves making such an application. Previously, until Lunes, because of the case of McCarthy, the Home Office was refusing those applications and was saying you can no longer rely on free movement, the Free Movement Directive, the regulations and so forth, because you're a British national. But that's now been corrected. So it's a very specific category of dual nationals who have acquired the British citizenship through naturalization, having come to the UK. So it's not a dual national, for example, who might have been French and Spanish, or British and Irish, but I'll come to that from the next category, by birth. So as I said, it's a very specific set of circumstances, but that category is fully catered for, and there's still no solution, and it's doubtful whether there will be, for the McCarthy type situation where you are a dual national, British and something else by birth, and you've always lived in the UK, apart for the persons whose other nationality might be Irish. And so we come to that slide now. And so this is a very recent development which is not yet in force. So it's headed persons of Northern Ireland, but essentially it covers persons with links, ancestry links to by birth and ancestry links to Northern Ireland, but also we'll see an Irish citizen, or a dual British and Irish citizen. So this change has come about again through litigation. You have it at the start of the slide, what's become known as the de Souza litigation, and it's been put into, it's been enacted, so to speak, through the statement of changes there that you've got hyperlinked, that was laid on the 14th of May 2020, so barely a month ago. The provisions that are being laid through that statement of changes that are going to come into force in Appendix EU are not to come into force until the 24th of August 2020. So you can't make an application under these provisions yet. It will be post 24th of August 2020. But essentially it is to correct again the difficulties that were experienced by many Irish citizens, dual citizens, British and Irish, or those who are born and have ancestry links in Northern Ireland. So it's a reflection of the Good Friday Agreement. So it brings the immigration rules that were long outstanding into line with that agreement. I've read only very briefly, not completely in line with the Good Friday Agreement. There are certain aspects that haven't yet been corrected, so to speak, but obviously we won't go into that during this webinar. But the requirements are, in a nutshell, that the sponsor, so the EEA national, in inverted commas, is a relevant person of Northern Ireland. Relevant person of Northern Ireland, as you can see from the second bullet point, is a definition that you find in the Good Friday Agreement. But it essentially includes, and this is all again going to be reflected in Annex 1 in Appendix EU when it comes in, it will include a British citizen who was born in Northern Ireland, an Irish citizen, again, who was born in Northern Ireland, so a citizen born there but Irish, or a dual British and Irish citizen born in Northern Ireland. It doesn't stop there. You have in brackets that they've also got to show that at the time of their birth, they had at least one parent who was, again, the various categories that can flow. So either a British citizen or an Irish citizen or dual, or even without showing any of that, might qualify if they were otherwise entitled to reside in Northern Ireland, and that is the parent, otherwise entitled to reside in Northern Ireland without any restriction at that, during their period of residence there. So essentially, those persons, so those categories of persons that have those links to Northern Ireland are now able to make an application for their family members under Appendix EU. So they would have otherwise had to make it through, if they were British, for example, through the immigration rules. So it does open up quite a lot of possibilities for such families, for example, because obviously the requirements are arguably easier to meet under Appendix EU than under the immigration rules. It will also apply, the last sentence that you've got on the slide, it will also apply to a qualifying person of Northern Ireland, so who's met all of those criteria that I've set out, but who's living in England, Scotland and Wales. So it's not restricted to such persons who are resident in Northern Ireland at the moment. So it's anybody with those links, with those ancestry links, that might obviously be residing elsewhere within the UK at the moment. I think that was all that I wanted to cover on Northern Ireland. As I said, really great improvement for now, but only applicable from the 24th of August. So we move away now from the categories of EEA nationals and other persons that would qualify under the Appendix EU, and we're looking at really the current developments during the pandemic and how that might have affected applications under the appendix, and then how the procedural ways of doing that. So can you still make an application? Yes, the process is online, has always really been a large focus on making the application supposedly as easy as possible, but also online. There is a postal procedure, for example, to send in the documents that you couldn't have checked through the app or online. So for a certain category of persons that may have been vital. That is also operational now from the 22nd of May. So there was a period where there were difficulties due to the pandemic, but that is now fully operational from the 22nd of May and confirmed by the Home Office. Can you, what are the difficulties if you can't produce a valid passport or national ID card? Now that may have become much more of a problem during the pandemic, but there was always guidance, and you have the reference there hyperlinked, there was always guidance to set out the circumstances by which you could avoid having to submit a valid passport or a national ID card. The guidance is fairly vague. It sets out that you may, the Home Office may accept alternative evidence of identity and nationality where the applicant cannot obtain or produce the required document due to circumstances beyond their control or due to compelling practical or compassionate reasons. So obviously, that would only be looked at on a case-by-case basis, and we know from other practices at the Home Office that beyond their control and compelling and practical compassionate reasons does tend to be very serious reasons. But there were provisions there, but they have built in more flexibility since the pandemic. So you've just got brief references there at the end of the slide. To other countries extending the validity period of their own identity documents because of the pandemic. So again, you've got the reference to the guidance there. Just as an example, Bulgaria, which is in the table, there's a whole table in the guidance setting out the countries certainly that are known or that, that have announced this officially. The first one, as I mentioned, is Bulgaria. Any document expiring between the 13th of March 2020 and the 31st of October 2020 is to be treated as having no expiry date. So there are flexibility measures there, obviously dependent on the country issuing the document, but already recognised by the Home Office in the guidance there. We don't know if that has been those sorts of measures have been put into place by the UK, so sort of reciprocal measures with British passports and their expiry dates. So I just flag that up, for example, for British citizens looking to return and making these applications under Appendix EU if there are issues with their validity dates, expiry dates on their own passports. But so that would be something to check. But certainly flexibility starting there, and obviously however long these difficulties are going to last for, there may be further announcements there. So do check, it's important to consult the operational instructions, both within the EEA guidance that may be updated, but also more under the theme of the pandemic and the COVID measures that the Home Office may have adapted. So that's just a brief overview on the documents, and I'm going to hand you over now to Samina just to look at any further difficulties under the pandemic.
Thank you. We're probably going to run over a little bit, but if you're all game, we're still here. So just looking at and continuing with difficulties that individuals might have or might be facing, is they might be asking the question, how will the application be affected if I have been outside of the United Kingdom due to the COVID-19? Well, they're right to be concerned, because they have to demonstrate a continuous qualifying period. And this is a period that's been defined in Appendix EU of the immigration rules. And it's defined in this manner. It's a period of residence that began before the 31st of December 2020, and which has not been broken by an absence from the UK exceeding a total of 6 months in any 12-month period. And this includes time spent in prison, removal, those affected by removal decisions, deportations, or exclusion orders. Of course, there is always going to be an exception to that. And the exception is also contained within Appendix EU, and it is that enables individuals for a single period of absence, which does not exceed 12 months, to demonstrate that for an important reason they remained outside of the United Kingdom, so that it can exceed 6 months out of the 12 months. So what we're seeing, that this generally at the moment covers serious illness, it covers a study, overseas posting, and any other childbirth. Sorry, I say any other, I say childbirth as well. So if you've been outside the United Kingdom for those reasons. So we don't see why it wouldn't extend to COVID-related difficulties, especially as we know, and Sarah's already highlighted, the government has been making concessions in other areas, and some of our other webinars have certainly explored within the immigration rules the concessions made by the government and extensions that are being granted to various other nationals. There's no reason why a similar concession couldn't be made for individuals who might have been stuck due to COVID-related reasons. What we would advise essentially though is that there are travel restrictions, but those are easing. They have eased for certain EU countries for some time. And what it might be best to do is, so that you're not caught out by the Home Office saying, well, you should have returned earlier, or you could have returned earlier, is to keep evidence of why you couldn't return any earlier. And it may well be that you were quarantined or whatever the reasons are, but just keep the evidence of it. Well, your clients might be wondering if your continuous leave is broken because you weren't, whether you're going to be asked to leave the United Kingdom because your continuous leave was broken. It's not, so they've got nothing to worry about. What it does is it restarts the clock, so they have to build up their 5-year, they go back to pre-settled status right to the start, and they have to build up a 5-year period of residence towards settled status. Of course, and I've already mentioned this issue of historical residence, you're looking at individuals who might already have a period of 5 years of historical residence in the United Kingdom, and even if they've been outside the UK due to COVID-related reasons, they can rely on that 5-year period. So it'd be interesting to see how that pans out, certainly. Now, I've added in here into this slide a little bit of a red herring, essentially, but individuals might have a query in relation to whether or not they can make an application after the deadline. We've considered where individuals might, which kind of individuals might want an extension on their deadlines, and it may well be British citizens who want advice that if they stay outside of the United Kingdom beyond this, the period that they're entitled to, would there be an extension for the date of the application by which the application needs to be made? Well, the answer is short, and it's within the UK-EU withdrawal agreement. Just for the sake of completeness, we've put in reference to Article 18C and 18D, and so long as they demonstrate reasonable grounds, test is a relative one, so as long as they are able to demonstrate those reasonable grounds, then there's no reason why they can't make an extension for an application when they put in their application. Well, if you've made your application, what next? And that application was refused. That takes me to this slide, which is administrative review. You are entitled, if your application is refused, to apply for an administrative review. It's slightly different from the traditional administrative reviews that we know of, and that's because it allows any kind of new evidence that's never been submitted to be submitted within the remit of the administrative review application. Again, we'd refer you to the hyperlink and the guidance here at page 114. It applies to anyone who makes a valid application under EU and is refused, or instead of settled status, they're granted pre-settled status. They can just add in any new evidence that they might have to demonstrate their entitlement for settled status. And we hear that the success rate is good given this requirement of entitling them to put in this new evidence. What we'd ask you to do is probably refer to Appendix EU, AREU, and that highlights how the administrative review works. One might think, well, why do we need administrative review when, as of the 31st of January 2020, appeal rights were introduced? Well, these only apply to individuals who made an application on or after the 31st of January 2020. But it may well be that we see a phasing out of the administrative reviews eventually, but for now it still exists, and there's no reason why you can't have a bite of the cherry, 2 bites of the cherry essentially at the moment. And time doesn't start to run for the appeal rights until after you've exhausted your administrative review application and you received a decision back on that, if it's a refusal. We hear there aren't many refusals, so hopefully you can give that a go when you have an application that's been refused. I will hand back to Sarah for the last couple of slides, and essentially she'll be talking about the grounds of appeal and then taking you through to the case law.
Thank you, Samina. Yes, absolutely. So at the moment we are seeing both systems working together, admin review and appeal ground. Certainly I was asked to advise on an application that was refused, as in pre-settled status was granted instead of settled at the start of lockdown, and that was only eligible for an admin review. So there is some delay, and also the delays in applications are still being reported and obviously will have happened because of the pandemic. So there may still be quite a lot of decisions that are subject to admin review only. But if you do make an application now and that is refused or granted with pre-settled status only, then you would have the right of appeal. So just a reminder here as to what you can appeal in terms of decisions. And the other characteristic to flag is also an appeal on a decision refusing on suitability grounds is one that you can appeal. So that was actually excluded from the admin review procedure, but I think the number of applications refused on suitability grounds was certainly very low and may still be very low as well. So the relevance of that may be less, but it's there now with the rights of appeal. In terms of grounds of appeal, they are fairly straightforward. The decision breaches any right claimed under the withdrawal agreement, the separation agreement, or the Swiss citizens' rights agreement in terms of the other countries that have specific agreements for those nationals, and also decision was not in accordance with the immigration rules under which it was made. So we're pleased to see back in and not in accordance with the immigration rules appeal ground, and so that is obviously very fairly straightforward in terms of taking us back to the immigration rules. So that is essentially the appeal rights for now. And we may see a lot more in practice as we go on into the scheme. Last slide to cover, and fairly quickly as we are overrunning already, is the case law that I referred to at the start that has some relevance still to this context. So the first is a very procedural one, but essentially the case of Amari is a case that looked at the regulations and the interplay with Appendix EU. So it concerned an appellant who had an appeal under the regulations, so they'd made an application for their residence card, permanent residence, I can't quite remember exactly, but under the regulations, and had since, while the appeal was pending, been granted status under Appendix EU, so had in parallel made that application under Appendix EU, which had been granted. There were arguments that that grant in itself, that more recent grant, would treat the appeal under the regulations as abandoned, so would have an automatic effect on the validity, on the continuation of that appeal under the regulations. But the tribunal, the upper tribunal, looking at all of those provisions, said that it doesn't. There are no provisions built into the relevant framework, legal framework, that say so. So you can have both in parallel, and so there are advantages to still continuing a regulations appeal. That may carry forward, for example, to British citizenship if persons want to naturalise in the future, may allow that route to carry on quicker. So that's just a simple procedural point there. And then the appeal of Cornwall is interesting, coming back to, again, extended family members. So now known as dependent relatives in Appendix EU, but it clarifies that in order to look at residence, and residence in accordance with the regulations, so again, regulations as opposed to Appendix EU, is residence that the residence is only recognised post issue of a residence card or a family permit in the case of extended family members. So it draws a distinction between family members under the regulations, where the grant of a residence card, the grant of a family permit is a declaration of their rights. It's not an actual giving of those rights. The person doesn't acquire their rights under EEA law upon the issue of that document. As a family member, they may have had those rights prior to the issue of that document, but not with the case of extended family members. That is because, in a nutshell, in the regulations, Regulation 17, the subsection in Regulation 17 provides a discretion to the Secretary of State to issue that residence card in the case of an extended family member upon an extenuous assessment of their personal circumstances. Extensive, sorry, not extenuous. Assessment of their personal circumstances. So it's only upon the issue that those rights as an extended family member are recognised. And that, of course, includes durable partners. So that's important for the calculation, for example, of permanent residence. You can't go prior to the issue of those residence cards. And it comes back to also very quickly in terms of why we've chosen this case for Appendix EU, for an Appendix EU webinar, is because, as Samina mentioned earlier, when you apply as a dependent relative under Appendix EU, you've essentially got to prove your relationship through a relevant document. That relevant document is defined as a residence card, family permanent residence card, etc. And so we think that is because of this discretion under the regulations and that assessment that needs to happen. So Appendix EU doesn't seem to have that inbuilt at the moment. Whether that will change or not is to be seen, because it's quite unsatisfactory that for durable partners, for example, under Appendix EU, you essentially have to make at the moment an application under the regulations first. So that gives a bit of background as to possibly why the rationales for that, which carries forward into Appendix EU. And lastly, the case of Cornwall and the rationale, the principles that I've just mentioned, was also recognised and confirmed in the Court of Appeal in the case of Abangbi from last year. So some meaty case law there, as I said, relevant for permanent residence applications, but also potentially to see the relevance in Appendix EU for dependent relatives and durable partners. So that is essentially the end of our content for the webinar. So we come to the Q&As. I'm going to launch the poll now while we have the question and answers. So if you want to multitask, please type in your questions into the Q&A if you haven't already, but also if you don't mind answering the poll, which should now have appeared on your screens. And I'm going to hand over to Samina to take, perhaps we'll have time for about 2 questions as we've run over quite a lot.
Thank you, Sarah. Yeah, sorry, I've been through some of the questions, and I think that Sarah's last slide may well have answered in relation to the case law, one or two of the questions. I'm just going to take some of the questions from the top. The first one, am I correct in understanding that if a non-EA dependent or spouse of an EU national applies for settled status, they don't have to apply for permanent residence card? That is, they have a choice of which one they want to apply for. The answer is yes, as long as they have the documentation to demonstrate the relationship. I think the only difference is going to be in relation to durable partners for the reasons Sarah's already explained. Sarah, is there a question that you've picked or?
No, but I will just in relation to that first question, what I would add is it's not 2 ways, I don't think. So if you apply under the regulations, if you have applied under the regulations, you've still got to make your settled or your pre-settled application under the scheme. So if you're sorted with permanent residence from years ago, you've still got to apply under Appendix EU to get that confirmed as well. But if you've done it under Appendix EU, you don't need to go back into the regulations. That's certainly my understanding of it, unless you're a durable partner.
Yeah, definitely.
But let's have a look at another question. So there's questions, if you have a family relative, not a spouse or a close relative, but a distant relative in Italy, would a British citizen be able to see them with free movement of travel, or would there be a restriction on the visa? So that is mostly an Appendix EU family permit, because obviously the person would be out of the UK and looking to come in and join the citizen here. At first blush, it doesn't seem that they could, because it's a British citizen who is here. If it's a British citizen who's in Italy as well, then it may be possible through the Surinder Singh, the Regulation 9 route, which has been put into Appendix EU. But it would very much depend on that relationship, what that relationship is. and whether it's covered in the definitions, and obviously whether they've been living together. There may be other requirements that you've got to seek instructions on and grapple with and see whether that qualifies you within the definitions. So not hugely answering that question, as it would very much depend on the circumstances and that relationship. I don't know if we have time for just one more, Samina, maybe?
Just one more, I think, and I'm going to just look at the question by Geet, and it says, is it essential for EA national students under the age of 16 studying in the UK to have comprehensive insurance to apply for settlement? My understanding was that the focus had moved away from the CSI and so on, and that they were going to be looking at residents only. So I think that I mean, we'd need to double check that, but I think the answer is that they'd look at the period of residence, because they've tried to make it more flexible and easier for individuals to apply because of the huge complaints and the campaigning that went on. There's a second part to that question, and I think that's a little bit different, because it says, do they need to show their sponsor? If they were an EA national student who are here within their own right, they wouldn't have a sponsor essentially. So I don't know whether that part of the question is being asked in a different context, but we're happy to answer those questions if you email us. And sorry we couldn't get to all the questions and answer questions. They're very interesting questions, but I think we've really overrun and run out of time now. So thank you all for being a part of this particular webinar, and certainly we'll look back to feedback. We look forward to feedback in relation to anything else you might want to see in the future, maybe in the summer months.